All right, so we'll go ahead and get started. The brief overview of the event. Brandon's going to present for about 20 minutes. Like I said, throw any of those questions. If you just joined, you can throw any questions you have in the chat there in Zoom. And the end will be those breakout rooms. We'll divide this into a smaller, smaller groups so that people can actually talk to each other and network like they would at an in-person event. I'd like to go ahead and thank our sponsor for this event, Luggage Hero. For any hosts who are in the New York City area or a lot of other cities that they're in, if you need a place to direct your guests to store their luggage, they do have an affiliate program that you can find on their website. So they'll actually give you a percentage of whatever you make, or whatever they make from the guests storing their luggage. So check them out. So I'm going to go ahead and introduce our featured speaker. He's spoken before. Some of you came to the meetup about, I think, a year and a half ago. His name is Brandon McKenzie. He's from Moss & Moss LLP, which is a full-service law firm. The firm's practice areas include short-term rentals, vacation rental litigation and transactions, real estate litigation, landlord-tenant litigation, administrative hearings, startup and technology matters, corporate counsel work, and others. And the firm also works with vacation rental and property management companies on master leases, acquisitions, guest rental agreements, and a wide variety of commercial agreements related to short-term rentals. So Brandon has done a lot of stuff, obviously around the violations and legal stuff in New York. So I'm going to go ahead and kick it over to him, and he'll get started on the presentation.
Great. Thanks, Mike. That was a generous introduction. I've probably done more of this than I like. And hopefully I don't have to do too much more. And I'm going to just flip through and see if any of my current clients are on here. Hopefully not. And hopefully you guys never have to be one of my clients. So today I'm going to try to keep this as 20 minutes. Mike's right, but I think that is pretty ambitious. There's a lot to cover, but I'm just going to keep this high level. Consider this nothing more, honestly, than a crash course on the Office of Administrative Trials and Hearings, or OATH. This is not legal advice. This is more for informational purposes, just to so you guys can cut your teeth on it. There's far more to this than I'm going to go into today, but this should give you a cursory understanding. So heaven forbid you get into a little bit of trouble with the city. You kind of have a baseline, a foundation in how to address this stuff. So I'm going to go ahead and share my screen so you guys can see all this. Can everybody see this? Can I get a nod, thumbs up? Yeah? Okay. So what is the Office of Administrative Trials and Hearings? And we're going to circulate this deck, by the way, or make it available. So OATH is an administrative law court run by the city of New York. And for those of you guys who don't know how precedent works, OATH is in a weird body. So typically the way things work is, let's say you sue somebody in New York State Supreme Court, in civil court. Let's say you lose and you have a right to an appeal. You can appeal, and there is a higher court. If that higher court disagrees with this court, this decision becomes precedent, and all the courts below it have to follow that decision. And so that's what lawyers generally do, is they point to higher courts and they said, the judge up there said X, so you have to follow what he said. OATH is in its own weird bucket in that they're charged with handling the administrative code. So that would be things like the housing maintenance code, fire code, just New York City administrative code generally, which occupies this weird place, outside of typical civil litigation. Now, there is a way to get back into regular court, which I'm going to go over a little bit later, but I just want to give you guys a little bit of context. You're almost operating in a closed universe when you get into OATH. So what I typically see when it comes to short-term rental hosts, Airbnb being, the most common one, I constantly get phone calls being like, I got in trouble for my Airbnb. And that can mean Airbnb, VRBO, Booking.com, what have you. But typically it's because summons are issued from the Department of Buildings. And what will happen is that's a complaint-driven process primarily. And what I'm seeing more and more and more is townhouse owners are the low-hanging fruit. You guys may have remembered me saying this from a year and a half ago. They will come up, Department of Buildings inspectors, they'll come knock on the door. They're usually plain clothes. Sometimes they'll have a detective with them, but they're usually plain clothes. They'll still have a badge. And they'll knock on the door because some neighbor called 311 and said, my neighbor is Airbnb. And there's a way to find that out, and I can show you guys that as well a little bit later on. But they respond to these complaints, and sometimes they're anonymous complaints, and heaven knows if, I can only speculate as to who's filing those complaints. Perhaps it's even a DOB officer himself. Sheer speculation, but I have my theories. In any event, these guys will show up, knock on the door, and try to catch an Airbnb guest in the act. And then their job, once they get there, is to gather as much evidence and information as possible. And so what they try to do is identify the suspect, in this case, the Airbnb guest, who, for all intents and purposes, is generally sort of the innocent bystander. They don't get in trouble. The homeowner does, or the building owner does. So they'll try to gather as much information from them as possible. And that usually takes one of two forms. They'll be sweet as apple pie and motherhood and say, hey, we're law enforcement, can you help us out, kind of thing. Or, hey, we're law enforcement, not saying, hey, I'm a DOB inspector. Like, they make it seem like they're, excuse my language, but like real police. And they'll flash a badge without anybody seeing it. And they'll say, we need to get into the apartment. And, the Airbnb guest, they'll say, can we come in? And they have to consent. They can't just force their way in without a warrant. So oftentimes, if somebody sort of misleadingly says I'm law enforcement, and you have a guest from Santiago, Chile, who doesn't have a perfect command of English, and they see somebody with a badge, they'll freak out and they'll say, right this way, we have a table waiting for you. DOB inspector will come in and take a lot of photographs. It's pretty common practice, and more often than not, they will ask the Airbnb guest, can I see the reservation on your phone, and take a picture of that. And that becomes evidence to use against the Airbnb host at the hearing later. So if I'm an Airbnb host and I want to increase my odds of not getting in trouble by the time it comes to the point of, hey, I'm in trouble already and I have a hearing, I don't want them to have that evidence. So I have to think about, look, if I want to practice some risk mitigation strategies, step one is, let's not talk to those folks at all. Let's not let them into my apartment. Can be easier said than done. It's I'm sure it's probably pretty challenging to call up your Airbnb guests and coach them and say, hey, if anybody knocks on the door, don't let them in without my consent. Not everybody's going to follow along, but good to know. So then what happens? Well, you're issued a summons, and that takes a few forms, but it's essentially a ticket that says, here's what we're charging you with, here's the law that we're accusing you of violating, and here's the date and time when you have to show up for your hearing. For DOB hearings, they typically take place on Thursday mornings, and not typically, they always take place on Thursday mornings if you're issued a DOB summons. And what they call the first time on, your first hearing, when you show up, 9 times out of 10, it will be your attorney or sometimes you in person and the DOB's attorney. They have to present their case in chief. And the way that works is they have to bring a witness to testify and say they did all this stuff wrong. And who's that witness? Typically the DOB inspector. 9 times out of 10, they will not be there the first time on. And it is a huge waste of time and a huge annoyance. And I have had many a shouting match with DOB attorneys, much to my chagrin, saying, where the hell is your person? This has been, I've been making demands of you for a year and your guy's not here. And I have been informed by the mayor's office and the Department of Buildings that their position is that is a waste of resources because they need their guys out in the field. And they don't care that it's a waste of your resources to have to pay an attorney to be there. So 9 times out of 10, you'll show up, you'll spin your wheels, you will waste your time, and they will reschedule it and kick it out a few months. It doesn't always happen. You should always be prepared for them to show up the first time. But in my experience, they often don't show up, and it's really, really annoying. They are also allowed to do that, which is also frustrating. When you speak to the judge will say, all right, typically they'll grant the DOB a lot of latitude and say, we're going to reschedule this for the presence of their witness, for their inspector. And they're allowed to do that twice before you can make a motion to dismiss for them failing to have their witness there. They're allowed to do that. So 2 times, and then you show up. So, you could drag this out 9 months to a year before your case actually gets heard. COVID's a little different. You would have to show up for a lot of specific violations. You'd actually have to be there in person. And there are sort of lesser violations that we're going to get into in a minute where you can do them by phone or electronically. Now they're basically saying, look, we're going to do as many of these by phone as possible. And that's great for somebody in my shoes because I don't care if their guy's out in the field. I can say, why isn't your guy here? Get him on the phone right now. He has absolutely zero excuse. I don't care if he's knocking on the door of a townhouse right now. He has a phone on him. Let's get him here Ready or not? So now we're going to go through what these things look like. And I'm hopefully you guys can see my screen. This is a sample summons. Sometimes, you know, they'll issue the cover sheet. They're on carbon paper, so sometimes they'll be yellow or pink, and they will typically mail you a copy as well unless they serve you in person. And I'm just going to give you a real high level quick on this. So this right here, the 000X, and here, and also at the bottom, typically, well, not on this one, identifies the summons, and that's in the oath system. So you can look it up. It doesn't go in immediately. Usually they'll issue you the violation, and usually there's 3 or 4 of these handed to you or, you know, stuck on your door. And you can go to this link that you can see on the slides here, and you can enter your summons number, and then you can get a bunch of information about it. So typically it'll start with a 3. On that link, you want to enter a 0 before the 3, and then you put in the whole thing. It'll be like 354J7X or whatever. And it will tell you your hearing date is X, here is the penalty amount for the violation, and here is the statute that you are accused of violating. So it's really useful information, and you can get a handle on it, and you can say, look, I've got 4 of these. What's my total exposure here? Am I looking at $5,000 worth of liability, or $25,000 or $100,000? That's very useful. Next, and this is very important for you guys to know, is I'm not going to go through all this. I'm going to hit the high notes here. The respondent. Now, I get a lot of calls, a lot more than I'd like, of people who live in Class A multiple dwelling, so large apartment complexes in New York, who say, DOB showed up, they stuck a summons on my door or whatever. What do? I'm freaking out. And their name is not in the respondent line. And they're like, I need to hire you. And my answer to that is, you cannot hire me to represent you on this one because you are not the named respondent. In New York, the building owner, and I'm going to repeat this so everybody gets it, the building owner is typically responsible for each one of these summonses. So let's say you live in a building with 300 apartments, and you're the Airbnb host and you get in trouble. Technically, you're not in trouble. The owner of the building is in trouble. They're going to be the respondent, and they're the party that requires representation. Now, that doesn't mean they won't come around, turn right around and try to charge you legal fees or sue you. But what it does mean is that you can't hire me to defend you against this because there's nothing for you to be defended against. That's the landlord. Date and place of occurrence are exactly how they sound. It's where did the bad thing happen? What's the address, the date and time observed? And they're going to make notes of that. And then they're going to put stuff in here about the hearing date and time, which is going to be a Thursday, you know, probably a few months out. Typically, they're going to check the 8:30 a.m. box, and they're going to put the borough. And so, you know, 9 times out of 10, you know, most of these things I show up for are in Manhattan. You Brooklyn hosts have been very well behaved lately, it seems. But yeah, it's down at 66 John Street in the financial district. So now this is interesting. The second half of this is the commission's order to correct. Now, if you see this cure date, this is rare. I never see these. Like, this is really rare. Cure date basically means like you've done a tiny little thing that is eligible for a cure. And a cure means you admit fault. You're like, I did the bad thing and I'm going to fix it. I'm going to prove I fixed it. And then you're not going to charge me any penalties. And then I don't have to show up for a hearing. That's super rare. 9 times out of 10, you're going to see a line right through that blank space. When there's a line through that, that means it's not eligible for a cure. Another thing you might hear or see if you look at the schedule that I'm going to show you on another page here is some of these are eligible for mitigation, meaning if you fix the thing, they'll cut your penalty in half. But again, not as common with transient use short-term rental violations. Must appear is typically checked now for short-term rental transient use things that I see. And that means you actually have to show up at your hearing if you intend to fight. Now you can just pay it and you can say, hey, I admit it. I did the bad thing. Here's the money and we're done here. And then you don't have to show up because you've admitted fault and you paid. If they check must appear, it means if you're going to fight it, you have to show up. And generally speaking, other than wasting a lot of your time, you don't have a lot to lose if you show up, because if you lose at the hearing, the penalty for showing up doesn't change versus just paying it. Where things do get problematic is if you don't show up. Then you get what's known as a default, and those penalties increase by about 5-fold. So never look at one of these and say, this is bullshit and the law is wrong and I'm just not going to show up, because then you're going to be in a much, much worse scenario. And then you have to file a motion to vacate the default judgment and reopen the case. Otherwise, you're going to be hit for huge penalties. let's see, what else? Complaint number, you know, this is useful. They'll put in the 311 complaint. So let's say I call, you know, Mike's my neighbor, and I'm like, I'm sick of his Airbnb nonsense, and I call 311. There's going to be a complaint number. It's going to say like 155347. And the 311 operator is going to write down the notes and be like, Brandon called and he said Mike's a jerk and he's doing all this Airbnb crap and we need to put an end to it. If you look up your own home in BizWeb, and I shared a link on these slides here, you can put in your own address and you can see anytime a 311 complaint has come in about your home. And you can look it up and say, oh my God, my neighbor called 311 and complained about me 3 days ago. I can expect that DOB inspectors are probably going to come knocking sometime this month. Better watch out. And the DOB inspectors will typically write here what the complaint number is for the complaint that they're responding to. Next thing is they're going to put a class of violation. This is hugely important. Class 1, Class 2, or Class 3. Transient use, I don't really see Class 3. I see Class 2 and mostly Class 1, which means immediately hazardous. In the city's view, they're saying this is something that's immediately hazardous to, you know, life or health of occupants, and we need to shut it down really, really quickly. If you get to a hearing and their evidence is weak and you want to cut a deal with a DOB attorney, sometimes they'll agree and they'll say, well, you know, will you just, you know, if you admit fault, we'll reduce it from a Class 1 to a Class 2. That takes a little bit of finagling. I wouldn't say I see that happen with a lot of laymen. I do see it happen with attorneys who understand how to navigate the system. And then the most important thing is provision of law. They're going to write in there what the actual administrative code is, what you're being charged with. They'll say, you know, 28-103.3. And then you can look up that law and say, what do they accuse me of? And typically, let's see, I'm going to jump ahead. That falls into these 5 buckets. These are the ones that I see more than anything else. And it's occupancy contrary to that allowed by certificate of occupancy. So if a building has a C of O and says this is for permanent residential use and you're using it transiently, you're going to get hit with that one. Failure to maintain building code compliant manner. I see this one in 2 forms commonly. They'll say, if you're going to use your building transiently, we expect that you have safety measures the same as other transient types of buildings like hotels, meaning, do you have an automatic sprinkler system that, you know, for a townhouse probably costs $150,000 plus to install, connected to the fire department that will go off automatically? Most people don't have that. Same thing about required means of egress. Do you have extra like doors and things like that for people to get out? Because the presumption that the city operates under is if there's a fire and somebody's there just for a few days, they're not going to know the easiest ways to get out. So you should have an additional way to get out, like a back door. I see permanent dwelling offered, used, or converted for other than permanent residential purposes, fairly self-explanatory. And then, you know, just like the sprinklers, we see fire alarms. So next thing. This is bad. And I feel like I'm giving a lot of bad news here. If you see this box checked, recurring condition or illegal conversion, these are not good, and vacate order is really terrible. It means you need to get out. Like, you're not allowed to live there until the condition they're accusing you of is fixed. I don't see that particularly often with transient use. I do see accusations of single room occupancy or SRO when people have locks on the doors of individual bedrooms. As far as the city is concerned, that's a fire hazard, especially if you have a lock on a door to a bedroom that accesses a fire escape, because if that door's locked, the building burns down, nobody can get out that door. What is common, it's the illegal conversion. Recurring condition typically happens if you've been busted more than once, and then the fines go up. The illegal conversion is particularly problematic because if that box is checked, it means you're going to get hit with additional fines of $1,000 a day. Now, they cap out at $45,000, and that's in addition to whatever the charge is. So if you've got a $5,000 fine and you let 45 days run, now you've got a $50,000 penalty. That's no fun. But you can stop the clock on those by filing what's known as a certificate of correction. You actually file an affidavit with it. And typically when they issue you these summonses, they will give you a form that you can fill out, your little affidavit, to say, hey, I'm going to file a certificate of correction. Certificate of correction, the purpose of that is to say, the thing that you're accusing me of is not happening anymore. So if you file that, let's say you file that after 3 days from receiving it, the clock stops. So now you've gotten 3 daily penalties of $1,000, so it's $3,000 in addition instead of $45,000. You got to be super careful with those certificates of correction, though, and those affidavits, because I have seen people DIY that and really screw it up, where it's an opportunity, but it can also be really bad for you because, like, let's say you say, hey, look, yes, I did have Airbnb guest, but I stopped, so it's fixed and it's corrected and it's not happening anymore. And you have to submit evidence. You can take pictures of an empty apartment, and they'll ask for things like that. If you say in that document, yes, I was doing the thing that's illegal, but I'm no longer doing the thing that's illegal, guess who might get that? The DOB attorney. And then you're going to be in an oath hearing trying to defend yourself, and they're going to say, look, here's a sheet of paper where they said I did the thing that's illegal. So, Your Honor, give them all the penalties that are attached to that. There are ways of framing the language where you can simply say, the condition that you accuse me of is not occurring. Here is a 1-year lease demonstrating that I had a permanent residential occupant for that time, not a transient occupant. Now you're not admitting that anything bad happened. You're just saying you're wrong and we're good. And then violation details are important, of course. This is where the inspector is going to put his notes. Let's see. All right, now here's the fun one. And Mike, I'm going to speed it up because I know I'm dragging here. This is an affidavit of service. This is on the reverse of the summons. And they're going to say the county and the date and the address. And then they're going to go through all this stuff. And there are rules in New York about how they give you these summonses. And they're strict. They're super, super strict because let's say you had DOB inspectors running around New York saying, oh yeah, he gave this to this guy. Sure. Oh, and he didn't show up. So let's give him 5 times the penalty. The city doesn't want that. They want to make sure you're actually getting this and you're notified of what you've been accused of. So they have to follow strict rules about how to put this in your hands. And typically the rule is they have to make an attempt, at least one, and in regular court, it's usually more, it's like 3 attempts, but here it's at least 1 attempt to serve a person of reasonable age and discretion who's qualified to accept service. Meaning if they knock on the door and a 13-year-old kid opens the door, the presumption is if they're under 18, they're not of reasonable age and discretion. If they don't speak any English, you can question, hey, are they of reasonable discretion to accept that? If it's you and it's your home, odds are they're going to say that's reasonable age and discretion. If you're not home and they knock or they try, then they can resort to what's known as alternate service. And they refer to this as a fix and mail. Lawyers will frequently call this nail and mail, where they'll make little notes here and say, this is what I did. This was my reasonable attempt at service. And it has to be reasonable. It can't be like, oh, I stuffed it, behind a trash can where there's no chance they're going to see it. It's like, I knocked on the door. I waited for 15 minutes. I found the guy's cell phone. I called him. He answered. He hung up on me. That's a reasonable attempt. Now you've kind of put them on notice. And then and only then can you take the violations, if I'm an inspector, stick them to the door, and then they also have to mail a copy to the address that they have on file. And usually they'll get that from Department of Finance or DOB records. And you guys, I think, would all be well advised to go on, look up HPD, Department of Finance, Department of Buildings, and find out whatever is out there about wherever you live, because you have to assume if you ever end up in an oath hearing, they're going to have that and they're going to see it. Now, if they serve somebody directly, like a person, that's what D is for. They're going to make little notes. I never see this filled out. They never check fair complexion, male, 14 to 20 years, under 5 feet. It's rare that I see this. What I usually see is this, C, and it's, I knocked the door, rang the bell, waited a few minutes, no response. I posted the violation to the first floor door of the building on the above address. There are a couple of ways to challenge this when you get to a hearing. You can say, either I can prove that the inspector didn't do that, or I can prove, the burden is on them to make their case. So you can say, did you mail it? And if they say yes, say, I never received it. The burden shifts back to them to prove that they mailed it. And they have to do both. So in this case, and I have permission from this client to show this, this is our friend Muhammad Yusuf, who I love because he loves to lie under oath. This is Mr. Yusuf. And as you can see, he's in plain clothes and he has a badge. There's an apartment at the garden level here, and I'm going to skip ahead. He goes in and has a friendly little chat with some folks in there, and then he leaves. He and his detective buddies, they'll leave. Yeah, there they go. And about 50 minutes passes. They're in the car writing up the summons, and then he comes back. I hope you guys are all as entertained by this as I am. So there's a summons in a nice little plastic sleeve. You can see the yellow copies, the pink copies, and the white copies. He's going to stuff them in there. By the way, huge fan of Nest. And there's a cheap version now called Kangaroo. They're about 20 bucks. Video footage is pure unalloyed gold. Now look at that. He sticks it to the door. God, I wish you guys could talk. I know you're all on mute, but I wonder if anyone saw him knock the door, ring the bell, or wait 5 minutes, because I didn't. And when I asked the judge if he saw that, or if I asked the DOB attorney if he saw that, they didn't see it either. It was really interesting. So that's a fun one. We also have this from another angle. Let's give this a quick look, just in case there's any confusion as to whether or not he knocked. So there he goes. I'll skip ahead. Now, I want you guys to see this. This is important. When he walks down the steps, he's going to take out his phone, and he's taking a picture of the summons that he affixed to the door and the address. And then he's going to, walk off and, probably go harass a bunch of other hosts for the rest of his day. Then he fills this out. This is his affidavit or affirmation of service that he is going to sign under penalty of perjury as a uniformed officer. And this has been a fun little thing that I sent to the DA along with that video, which presumably they will do absolutely nothing about, unfortunately. They have a public corruption bureau for uniformed officers. So he really shouldn't be signing this. The good news for me is when I bring this up, that means service is defective. If you guys remember anything I say about service, it's that you want it to be defective, and that is procedural grounds for dismissal of the entire case because he does not have proper jurisdiction. He didn't serve him properly. The entire case gets thrown out, which is awesome. The bad news there is the city now, I'm sure some of you guys have heard, they're firing 22,000 people and they've got a multi-billion-dollar hole in their budget. So in some cases like this, when they are dismissed on procedural grounds, I generally see them historically, those go away forever. Recently, in the last month or two, I have seen the city come back and attempt to reserve them properly and restart the whole case, which is a really lousy, lousy move. So that's always a risk, something to be mindful of. Basics, heaven forbid you get there. You're going to have this housekeeping in the beginning, scheduling, rescheduling, adjournments. Usually what that boils down to is you can reschedule. You can ask beforehand. There's a form online. You can say, hey, can't make that date. Can we push it out? Here's my availability. Usually what happens is you show up day of, they don't have their inspector, and they say, Your Honor, can we kick this out to get the presence of the inspector? We'll come back some other Thursday. What's particularly aggravating about that is they usually know the inspector's schedule, and they know they're not going to show up, and they won't tell you that in advance. Discovery, this is something that I do, and most attorneys I know do not do this because there's a cost calculus here. You are entitled to discovery. And so typically what I will do is I will serve a discovery demand on the mayor's office and the Department of Buildings the minute somebody retains me. And I will say, we want your list of witnesses that you intend to introduce, and we want all of your evidence, every single thing. I want the contemporaneous notes from the inspector. Whatever he wrote in his notepad, give me a scanned copy, and I want it well before the hearing. And usually they send it. Sometimes they don't, but usually I get it. Sometimes I've gotten it the night before the hearing, which is incredibly aggravating. But then I know what I'm up against. I'm like, all right, this is now a closed universe. Because if I get there and they try to introduce new evidence, I can flash that discovery demand in the judge's face and say, Your Honor, I served a valid discovery demand. It took a year and they responded last night. This is all they have. I objected the introduction of anything else or any other witnesses. And the judges have a little bit of leeway to let other stuff in, but generally speaking, they will follow that rule and they'll say, you know what, that's fine. We're closing the loop. No extra evidence, nothing else. And if you do these by phone, we email it all. So you want to bring that up very, very early on because DOB attorneys are notorious for trying to email evidence and be like, here's all our evidence, including stuff that they didn't provide in response to the discovery demand. You can't unring that bell once the judge has seen it. So I like to close that loop, and sometimes they'll say, well, what if we give you time to review it with your client? And we'll kindly say back, sure, if you want to stipulate to dropping one of the violations to cover my time that my client will have to pay me to review it, unless you want to pay for it. And usually, they'll play nice in the sandbox, and we'll close the universe, and then we'll say, all right, it's just these pictures, just this evidence, whatever they have. Then they start. The format typically goes, we note our appearance. So I'll say, I'm Brandon McKenzie here for Moss & Moss LLP. I'll state the address, my phone number, email, and I'm here on behalf of. They do the same thing. They introduce their witness, and then we dive right in. And typically that starts with them asking their witness questions. Then I cross-examine, and sometimes they do redirect. So that's case in chief, direct examination, then my cross-examination. Then I am allowed to introduce witnesses if I want to. Generally, I don't want to. That's respondent witnesses. Every once in a while, there's a good reason to bring somebody in and say, look, this guy saw this, you know, ask my brother if I'm a liar. And then the process goes in reverse. They get to cross-examine my witness, and then I can do redirect. Then usually we've wasted a bunch of time and everybody's tired, and the judge will say, all right, can we let the witnesses go or dismiss them or have them wait out in the hall or hang up the phone and we'll call them back if we need them. And then myself and the DOB attorney will make our legal arguments. And that goes back to that precedent thing that I was talking about. We'll look at all the old cases, every appeal that's been decided, and say, some other judge said this is why I should win. And they'll say the same thing. Some other judge said this, and this is why I should win. Then we'll make closing statements, and the judge will say, great, I've got everything I need. And sometimes I'll make a motion, you know, say, they don't have enough evidence, I move to dismiss. You know, sometimes it works, sometimes it doesn't. The judge usually will say, I'm going to reserve my decision. You will get it in the mail within 30 days. And then you'll get a letter in the mail saying, did you win or did you lose? From when you receive that, you have 30 days to appeal the decision. It's appeal by right. You're like, they can't stop you from appealing. And that's on issues of law. Typically, if it's sent by mail, you know, instead of issued right there, they give you an extra 5 days. So that's at 30/35. During COVID, they've extended this now to be 60 days or 65 days. And that, you know, that's for your appeal. If you don't file it, it's a use it or lose it. Like if you don't appeal, it's done. And either side can appeal. Then at that point, you have done what's known as exhausting all remedies. Like you've done everything you can. You've hit a wall with oath. And at that point, and only at that point, if you still don't like the outcome, you're allowed to bring what's known as an Article 78 proceeding for the next 120 days. And that is like a real lawsuit. Like you're moving the case to real court, to New York State Supreme Court. Generally, you only see this when people are, you know, have a lot of money on the line, or, you know, something was just horribly decided. Article 78 proceedings are great because you get to sort of restart the whole process and introduce evidence, like fresh evidence. It's not just on issues of law. So I'm going to burn through this quick because I know I'm way over time now. But are you under an obligation to provide inspectors with access to your home? Generally, no. What documentation is relevant for oath? Where can you find it? BISWeb, DOB, HPD, Zola. These are all great places. 311. Find out anything and everything you can. In fact, the minute we're off this Zoom call, I want everybody to go to all those websites. Go to BISWeb, and there's a link. It's further up on here on one of these, BISWeb right here. If you click this and you put in your address, you will learn a lot. You can see your certificate of occupancy, and the certificate of occupancy has all sorts of fun stuff. It'll tell you whether or not your building has automatic sprinklers or, you know, fire alarms. Sometimes it's blank. Sometimes there's no certificate of occupancy at all, but you'll learn a lot, and you'll see 311 complaints, and you'll know what sort of evidence they might have just from public records that they can weaponize against you. How can you monitor threats and compliance issues? Again, BISWeb, great place. Check out 311. Some of the risks of representing yourself. I get this a lot. I get a lot of calls where people say, hey, can I just waste an hour of your time and try to, you know, extract whatever information I can from your brain so I can go represent myself? I get that there is a natural instinct to save money. 9 times out of 10, that is a terribly, terribly stupid idea. I would never turn to a surgeon and say, hey, describe a rash over the phone and then think, oh yeah, I can figure this one out on my own. Like, not a good idea. So in terms of representing yourself, I'd say the biggest risk is if you're going to give testimony, you are then subject to cross-examination. So a DOB attorney could very easily ask you, were you doing the thing that's illegal? And then you're under oath. And do you want to commit perjury? Probably not. Usually a good idea, you know, provided that the summons fine justifies it, sending an attorney. There's a reason people like me exist. So some of the risks of hiring an attorney, I'd say there are different tiers, you know, and I go into this a little bit later. My view is good work's not cheap, cheap work's not good. There are representatives you can send. I think there's a website called like codecompliance.com or something like that. No, it's a different, yeah, codecompliance.com. These guys mostly do like building construction violations. They're a warm body in the room. It's if you have work and you need to just have somebody show up. Sometimes that is money that you spend that, I don't know how to put this. Like, you're worse off sending that guy than showing up yourself sometimes. I've seen that. I know some good attorneys who are relatively affordable because they have good relationships with DOB attorneys and they can cut deals and reduce things from class 1 to class 2. And then there are folks that I would sort of put our firm in a separate camp, and there are others like us. There's Bebnatov, I can't even pronounce the name, Curry. Vivian Curry is the attorney over there. He's a great guy. Our firm, there's a few of us out here who treat oath hearings like real court, like New York State Supreme Court. We serve discovery demands, and we cross-examine witnesses, and we raise every objection possible. And the trade-off there is we're spending a lot more time doing doing hearing prep, and we take this a lot more seriously. We research precedent, which means, we have to account for that in our with our hourly, with our time. And so costs tend to go up. So there are pros and cons. That's sort of the 3 buckets I'd put them into. It's almost like, 4. DIY, essentially useless, cheap, mixed results, and then people who take things very, very seriously, like trial attorneys, but are, for lack of, generally speaking, more expensive. Now, the next thing, I know a lot of you guys have been asking about this Airbnb law. This is the thing I spoke on about a year and a half ago, was the Airbnb lawsuit with the city. They cut a deal. And local law 146 was signed, I think August 9th or maybe August 16th. I'm blanking, middle of last month. And 6 months from that date, Airbnb is going to start turning over host data to the city of New York on a quarterly basis. Nothing retroactive, it's all prospective. So everything moving forward. And they will share information for people who are renting out entire host homes, not private rooms or shared rooms with 2 or fewer guests. If you have more than that, they'll share your data. And they'll give things like name, address, listing ID, the URL, it's like airbnb.com/whatever your unique identifier is. Basically anything and everything they need to figure out exactly who you are when you've had guests and what the guests were like. And what that means is now the city's going to have that. Their enforcement burden is eased considerably. They will have a lot of information to know where you are, when to get you. So if any of you guys are hosting and you have concerns that what you're doing might not be 100% above board or totally legal, keep that in mind. Might be a good time to think about getting out of business. Risks associated with certifying correction, I've already mentioned. That's just be careful what you say. And again, if you show up to an oath hearing, you say, yeah, I did the illegal thing, but the law is not fair. The judge doesn't care that the law is not fair. All they care about is, did you do the illegal thing? And then default risk is that increasing penalties. So what's the role of the attorney? Take a look at that tank right there. What if the law says no vehicles in the park? Can I just get a show of hands from people who have their cameras on? Is that a vehicle? No hands. Is it a monument? Yeah, Mike thinks it's a monument. So this is like the most basic example of what lawyers do. If the law says no vehicles in the park and somebody puts that in, one attorney is going to represent the guy who owns the tank. The other is going to represent, local townspeople who are unhappy about the tank. And the lawyer's job is to marshal the facts into the law and make arguments. I'm going to make the argument that it's a monument. The other guy's going to say, no, it's a vehicle. Well, what defines a vehicle, right? And your attorney's job, if you hire one for this, is not to get you off. If you've done the illegal thing and say, hey, I did a lot of illegal things and I'm in trouble, will you get me off? That's not my job. My job is to look at the law and say, the law says this. Is there an argument to be made that says what you are doing is somehow acceptable? And typically what an attorney will do is say, we can pursue this argument, or this argument. Here's pros and cons of each, and then leave it to you to pick. I tend to be a little more, for lack of better phrasing, aggressive. I like to present a plan. I like to say, here's 3 options. This is the one that I favor and here's why, but here's the pros and cons of each. But ultimately, as the client, it is your job to decide the path forward. And if you don't like the attorney's plan, it's probably not the right attorney for you. And if you say, hey, just, lie under oath or do the illegal thing, I'm probably not the right attorney for you. And if you don't like the law as is, if you're like, hey, Airbnb should be legal, the best way to go about that is to vote in politicians who will work to change the law, not to show up in an oath hearing and say, I did the illegal thing, because then you're just going to get hit with a lot of fines. So here's decisions, things that you need to consider if you're looking to hire an attorney. What are the facts? Do they have you dead to rights? Do they, when you're looking through it, let's say you serve a discovery demand and you get a letter back and you're like, here's all their evidence, and they have a lot of pictures that show that I was clearly doing the illegal thing. it doesn't make a lot of sense if you're just nailed to the cross here to spend thousands of dollars on an attorney only to end up in the same place. You know, you might just, you know, take that one on the chin and say, hey, I'm going to take my licks, I'm going to pay the fine and move on with my life. Then there's the exposure versus cost consideration. The city has taken to issuing a lot of advertising violations, saying, hey, you're unlawfully advertising on Airbnb. Those violations are $1,000. My fee is a lot more than that. Don't hire me for that. That's a waste. Pay it and move on, or fight it if you can, or send a warm body to fight it on your behalf. I have copied the penalty schedule there from Oath, so you can see exactly what each of those statutes lines up with, and it's very long. It's big. There's a lot of laws you can break. And it'll say, here's the base fine. That's like if you just decide to pay it, or if you show up at Oath and lose. The default penalty, which is usually 5 times. Mitigated, which is usually cut in half. And then, is it eligible for cure mitigation? Not all of them are. This is an old schedule. Oath has not updated its website. That's from 2014. The penalties have gone up since then. So assume that whatever you see on that link is not correct and the number is higher. That's why you look at that other website that I linked above. Perjury risk, we already talked about. Don't lie under oath. And if you think you're going to lie under oath or you have to lie under oath, don't go. Hire an attorney, send somebody else so that risk does not arise. Skill, do you understand how to navigate the law? If you're thinking, hey, I'm going to DIY this one, do you know where to find cases, where to find precedent, how to look up the law and figure out what appellate decisions favor you, or work for you or against you? If you do, more power to you. That's awesome. Like, that's really good. I wish more people did. But unfortunately, most people don't. And then again, finding the right advocate, find somebody with a plan. It's always a good thing. There is no certainty at trial, no matter how good your case is. I could walk into a hearing one day with a judge who's just having a bad morning and doesn't like the look of my face. I can be strong in the facts, strong in the law. That is always a risk. Fortunately, it doesn't really happen to yours truly, or hasn't happened yet, knock on wood, but it's always a risk. Trial is always a risk. There's no certainty. So that kind of brings me to my next thing. Never ask your attorney for Vegas odds. I get this constantly. People are like, what do you think my odds are of winning? No attorney is going to tell you that. No competent attorney is going to tell you that, because A, they don't know. All they can tell you is, here are the facts that are on your side. Here's the law that's on your side. Here's my plan, and here's how I'm going to attack this. Again, absolutely no certainty. There are loser cases. I get calls where I'm like, you have no case? Like, I won't take this one. This is a bad idea. But if I hear something, I'm like, oh yeah, he just showed up and stuck it on my door and then left. I will ask questions and say, did he knock? Did he ring the doorbell? Was anybody home? And you can see how the wheels are turning in my head, where I'm thinking, oh, is there a case for dismissal for defective service? It's a procedural defect. And I'll do the same thing on substantive. They'll say, oh, they issued me a ticket for no sprinkler system, but I have a sprinkler system. My next question is, what kind of sprinkler system? Is it documented? Is it in the certificate of occupancy? And now I'm thinking to myself, is there an argument to be made that he screwed up? It's not, we're going to win this 100%. It's, I'm information gathering. Next thing. Communication. I hate that I have to say this, but I do have to say it. If you hire an attorney, he's not your drinking buddy. Text, WhatsApp, Facebook, Instagram, these are not appropriate methods of communication for your attorney. Call their office, make an appointment, schedule a call, send them an email. I love email. I live on email. I will read that shit at 2 a.m. and you will probably get a response. If somehow you get a hold of my cell phone number and you text me at 11 o'clock on a Saturday, I'm not going to feel super motivated. Like, I'm still going to have to do a good job because I'm ethically obligated to. I'm not going to love you if you do that. So, we're not in high school. This isn't your buddy. Be a professional. Again, fees, good work's not cheap. Cheap work's not good. Don't send a prospective attorney. If you're vetting attorneys and you're meeting people and saying, who do I hire? Don't send them, 16-page single-spaced emails. It's not going to work. I don't know any attorney who's going to respond to that. And it's immediately transparent. It's like, people go to law school for 3 years and then practice for years and years building up skill sets. Nobody appreciates it if you call and say, hey, can I waste an hour of your time to try to, siphon off little bits of information to go do a poor job representing myself, and then potentially try to hold you accountable because you gave me bad advice. A lot of attorneys are terrified of malpractice risk, which is why at the very beginning of this, I had to qualify this and say, this is information. None of this is advice. So do with it what you will, but I am an attorney. I'm not your attorney. I'm not advising you guys one way or another. And then, of course, be ethical. don't ask your attorney to break the law. Don't tell your attorney, hey, I'm just going to lie under oath. Like, I don't want to hear that. I don't want to know that. Don't ask me to break the law. I will fire you as a client. I will say, I cannot continue to represent you if you're going to do like naughty things. That's not a good idea. On the flip side of that, I do appreciate it when my clients are honest with me. Even if you did the bad thing, my job, like I said, marshal the facts into the law. Just because you did something that's potentially illegal doesn't mean that you're going to lose. Doesn't mean your case is a loser. Like, there might be other reasons that your case gets dismissed, notwithstanding the fact that you did the illegal thing. So if you're honest with me, I can think around that. I can navigate it. If you hide information from me and I show up at a hearing and the DOB attorney introduces that evidence and I'm blindsided by it, that's really bad for you. My arguments are just not going to be as strong because I'm not going to be prepared for that argument. And besides the point, once you hire an attorney, your communications are privileged. I can't tell anybody what you told me. That's confidential. That's between you and me. It's like your attorney, your therapist, and your priest. It's like we're tight-lipped. So that's about it. And I guess the last thing, and I know I'm way, way over, so really sorry, Mike. But the last thing is we have been working with Enrico Schaefer. I know some of you guys already know him. There is sort of a movement right now of people trying to put together, or people trying to form a class for class action. Right now it's broken down into thousands of individual arbitrations. Airbnb's terms of service say that if they piss you off, they violate their own terms of service. Before you can sue them, you're supposed to bring an arbitration claim. We have made that process a lot easier to help you DIY it. And then for obviously huge claims, complex claims, we can still help. The more of those that happen, the better. Airbnb, as many of you guys know, overrode its own terms of service unilaterally, which is essentially breach of contract at the beginning of COVID, and just said, hey, we're giving everybody refunds, host be damned, you're all screwed. They're not supposed to do that. That's not allowed. So a lot of hosts have taken to filing individual arbitrations. Now, we're working with a sister firm right now on sort of consolidating all those people, figuring out who they are, where they are, and the more of them, the better, because let's say we hit a critical mass. Let's say we've got 10,000 of you guys filing individual arbitrations. Yeah, it's annoying, but every one of those, Airbnb has to pay a fee to respond to you. And if there's too many of those, Airbnb is going to be like, God damn, there are a lot of these and it's costing us a lot of money. And now we have to send lawyers to each individual arbitration and it's just going to become unwieldy. So the presumption is if we get enough people, Airbnb might waive its right to, force things into arbitration and say, screw it, we'll waive it. We're not forcing it into arbitration anymore. We'll let this be a class action. Go ahead, certify your class, and then we're only fighting one lawsuit instead of 10,000. So if you guys are interested, if Airbnb has really wronged you or pissed you off, at the end of the day, Airbnb is Airbnb's friend, not necessarily yours, as we saw with them sharing your personal data a few months from now. So if that's of interest to you, that link is on that last slide. It's mossandmoss.com/Airbnb. Happy to chat with you about it and figure out, which bucket you guys fall into and see if we can help you. That's it.
Awesome. Thanks, Brandon. We got a couple questions actually that came up in the chat over here, so I'll read them.
Really? You don't say.
Let's see what we have. We have a two-family home. What rules apply to us? We thought 1 and 2 family homes are exempt from Airbnb laws, and we were allowed to Airbnb. What's your take on that?
God, I love this question because I get it so often, and I'm sorry to disappoint for the person who asked the question. It is by and large wrong, and it's sad. Basically, here's the deal. The way I like to think about this is just because you have a driver's license doesn't mean it's legal to speed. It's the simplest analogy I can give. If you have a 2-family home, even if you are zoned in such a way that transient occupancy might be permissible, there's an interweaving of mishmash of other laws that apply to you. And this is what I see constantly. So people will say, look, I'm zoned, class B, I'm allowed to have people here for such and such a reason. And if you're zoned that way and a transient use is allowed, you still have to follow all of the other administrative code rules for transient use. So yeah, you can have guests transiently potentially if your building is zoned properly. And you can look that up. There's a link on here for Zola. You can look up your apartment or your home or whatever and see how it's zoned. You might be zoned for transient use, but then you have to follow all the other rules. So a DOB inspector comes and says, yeah, it's zoned for transient use. So I'm not going to get them on a summons for use contrary to certificate of occupancy, but they're using it transiently and they don't have the proper fire safety equipment for transient use, like an automatic sprinkler system. They can still get you for that. So it's not a clear yes or a clear no. It's maybe at best. The good news is, as of May, and Mike and I were just nerding out on this before we started this, there's this guy, bless him for fighting the good fight on all your behalfs, because God knows it must have been, I think Airbnb bankrolled this lawsuit actually. So, you know, maybe I'm giving him too much credit. There's this guy that Airbnb likes to parade around. You know, I don't know if any of you guys have been to any of these like city hall like meetups. It's like people with like, you know, picketing fences being like, change the law, and Airbnb will, you know, cart people out and say, show up, and, you know, try to make it disproportionately people of color to make the city appear racist, which, you know, I cannot tell you how many times I hear this from hosts being like, I'm actually offended that Airbnb is calling me and not all these other people. And one of these people happens to be a guy named Skip Carroll, who's disabled. And Skip, they like to use as a poster child, because they would say the city is just picking on ordinary New Yorkers and, you know, a disabled guy no less. How offensive is that? And Skip is based in Queens, but he went through the oath procedure. You know, he had his oath hearing, and then he appealed, and then he moved to an Article 78 proceeding and brought it into real court. And once it got into real court, that was in New York County, so in Manhattan. And the judge in May handed down a decision. So now we have precedent, which is great, if you guys all remember how that works, that we can weaponize, where the judge says, the law says that, you know, an R3 occupancy. So if you look up zoning rules, look up R3, you know, it's like a 2-family townhouse. So it'll say an R3 occupancy is to be used for permanent residential occupancy. That's what it permits. But it doesn't say explicitly that it prohibits a bunch of other things like commercial use or transient use or whatever. So interestingly, the judge says, yeah, he was using it for permanent residential occupancy. He lived there while this was going on, and he also used it transiently. There's nothing in the law that says he can't do both simultaneously. So he gave us precedent that says, yeah, if you've got an R3, like, you can use both side by side, which is awesome. And I cannot tell you how many times I've tried to weaponize that whenever I see an oath hearing when they'll say, hey, look, you know, it's a 2-family townhouse, it's R3, and we want to get them on all these violations. I'll say, not so fast. We have the Carroll decision. And inevitably from the ALJ, the administrative law judge, the hearing officer at oath, they'll say, I don't know that precedent applies to us because, like I said, we're in a vacuum. We're our own little administrative thing. And I very quickly point out, I'll say, that's fine. But inevitably where this will result is if you decide against me, I will appeal. And then at the end of those next, you know, 30 days or whatever, in that 120-day window, I'll bring an Article 78 proceeding. And guess what precedent does control the Article 78 proceeding? Exactly what I just said. So let's all save ourselves a lot of time, hassle, and expense. So you townhouse owners with R3s, check out that decision. You know, if you want some dry, like terribly boring legal reading before bed tonight, I believe it's Carroll v. Office of Administrative Trials and Hearings.
We have another one over here, Brennan, saying they spelled our street name wrong on the documents. Does this mean it will get thrown out in court, or is it still valid?
Okay, so 2 things. Number one, this is a common thing, and I want to just point this out to everybody. And this is no offense to the person who asked the question. It's actually a very good question. Questions like that I get a lot. Does this mean it will get thrown out? This is looking for certainty. That's not certainty that I can give. That's going to be a judge's decision. If they get it wrong, then potentially, yes, that is a lawyer's job to make the argument, to say they got the street wrong. You know, you're issuing a violation for a different address than, you know, the one cited here. Yeah, you can make an argument to get it tossed. As a counterweight to that, what DOB inspectors will typically do is write a lot of zoning information right on the summons. So it'll say block and lot. I don't know if you guys saw those blank lines. It'll say block 32, lot 3. And that is another identifier for the building. And if the judge can reasonably identify what the building is from that information, this is going to be the judge's discretion. It's their call. It's an appealable issue. You can say, hey, I think the judge got it wrong, and then leave it up to the appeal. But the judge might very well say, I can identify the building with reasonable certainty and specificity from the other information. Sorry, there's a typo. You know, it's on a corner. It could have been, you know, 121 this street or 121 this street. and I have no idea. If they've got the other information, that could go either way. And if you have a good lawyer, they're going to make the argument that yours should be tossed. May not be a winning argument.
Okay. Next question we have is, do you know the date or time frame Airbnb is starting to release that data to the city?
Yeah, so it's 6 months after it was signed into law, so that puts us early mid-February. I could look it up, you know, if you guys want to hold and look up the exact date, but I'd say check my slides. Somewhere on those slides, I think under local law 146, I hyperlink that to Airbnb's page on their own website where they talk about applicable New York laws, and they mention the date that it was signed into law. So it's 6 months from whatever that date is. That's, you know, then they're going to start turning over your data quarterly.
Someone asked, what types of witnesses do you often see at the hearings, and some tips about getting, I guess, what usually gets a case dismissed on procedural grounds?
Defective service is a big one. They screw that stuff up constantly. Because these guys, when they're out there, you have to assume they're responding to a ton of these. They're super busy. That's why the city has this weird policy of, we don't even take them out of the field to like do you the courtesy of showing up for the hearing where we've accused you worth of $15,000 worth of crap. These guys are going from townhouse to townhouse to townhouse or apartment to apartment issuing summonses. And so they get lazy and careless, and they just take these summons and they'll slap them on the door and move on. So that's a good procedural defect. I've seen some where they've named the wrong respondent. That's a good one. They'll get tossed on that. Defective service takes a few different forms. It's like, did you mail it? And they have a whole mailing system and data records where they can look up, hey, was it mailed? It's all supposed to be automated. Did they timely file the affidavit of service? So they have a time window where they have to, like, that affidavit of service where they're like, I served it in this way. They have to take that and the summons itself and put it into the oath system. If they don't do that in time, the whole thing goes away, which is awesome. And then I'm trying to think of other ones. If you have a deceased respondent, that's an interesting one. So like, let's say it's you and your spouse, and you know, you like they serve your spouse who died a month before the thing happened. That's a good one because, I mean, it's not a good one, but like that's a grounds for dismissal because basically, what are you going to do? Collect a judgment from a dead person? Same thing about if they, you know, if they get your name wrong, it's like, how are they going to collect that? It's like, now there's a judgment against a fictional person. Like, good luck. You have fun collecting that. Address wrong. These are all pretty basic ones. A lot of time though, lately, like I said, wherever the city can now, they'll try to take a second bite at the apple, which is, that's new. I'm seeing them taking a more aggressive posture there. Throw me a curveball. Come on, give me a tough one.
We have a next one is, I rent my apartment and rent a guest room on Airbnb. I am always home during these visits. I assume that means when the guest is there. Is the city likely looking to pursue this type of scenario legally?
That's a good question, and I like the way that's framed. Are they likely looking at that? Yes and no. Generally speaking, their official posture is, hey, we're not like trying to go after, you know, ordinary New Yorkers. If you're doing the entire apartment, potentially yes. If you're doing a room, I'd say you're probably lower, and I can't say this with absolute certainty, but you're probably lower on the priorities list. There are people out there that they're going after who are running 50, 60, 100 individual units, or at least were pre-COVID. They're going after those. The townhouses are easy because they can walk up the steps, knock on the door, and some unsuspecting Airbnb guest will fling it open and say, yep, I'm doing all the bad things. But so, you know, if you're renting out a private room, that's not even, as long as it's fewer than 2 guests and you're not running an SRO, you don't have locks on the doors or pressurized wall, like illegal walls or anything like that, you're probably not super high on their priorities list, especially if you're in a complex. You know, one thing I'm seeing is it's harder and harder for them to get into these buildings. You know, it's like, let's say you've got a 300 unit apartment complex with a doorman. It's a lot harder to get by a doorman onto an elevator, up the stairs, and knock on the door at just the right time when that person's home than it is to sit in a parked, you know, parked car in front of a townhouse and see when people are going in and out.
Thanks, Brandon. And then we have one last one here. So as a question is, when we talked about this before, what is the data that Airbnb is handing over to the city? That's only going forward, correct? It's not retroactive.
Correct. It's all prospective. Starting, it should start early mid-February, and then it's from there on out. Every quarter, they're going to give these massive data dumps. I've seen them, because I assume I've seen them, when in our big cases in New York State Supreme Court, when Airbnb responds to a subpoena, there are probably people who might be on this call who I've seen your data already, because Airbnb is very forthcoming in response to subpoenas. They'll say, here's a ream of data. They're giant Excel spreadsheets, and some of it's anonymized, but most of it's not. They'll show credit card numbers redacted except for the last four kind of thing, email address, user ID, name. I've seen things in subpoena responses where, front and backs of driver's licenses. So assume that whatever you've put into the Airbnb system, there's a closed universe on the information that they're supposed to share. But be mindful of that. Think about what you have shared with Airbnb in the past and how comfortable you are with that information being out there.
Awesome. I think that wraps up the questions for Brandon. Thank you again, Brandon. This was awesome.
Yeah, really good questions, guys. Much better than last time. No offense to the last group.
Cool. So we're going to send out Brandon's presentation after. So, if anyone wants to get a copy of that, I'll post it in the Facebook group. I'll shoot it in the email as well. It will have his contact information in case anyone has additional questions. Anyone who wants to hang around, as I mentioned, we're going to do the breakout rooms a little bit. And what that is basically we're going to split this chat into smaller groups so that we can not miss out on the person-to-person networking thing. Feel free to stay if you're interested in that. We'll probably do like 2, 3, or 4 minute rounds of that so everyone can meet each other. And yeah, if you have any questions that come up after, feel free to also post them in our Facebook group as well. And I'll go ahead and kick out the breakout rooms now.
Awesome. One more thing before we shut this down. Just a quick reminder. I know I said a lot and you guys are probably tired and heads are swimming after all that crap that I just threw at you. Seriously, if you forget everything I said, do take time. Take 5-10 minutes. HPD, Department of Finance, Department of Buildings, BizWeb, Zola, which is zoning and land use. These are all publicly available resources. New York City run websites where you can look up information about your apartment. You can see 311 complaints. You can see your certificate of occupancy, how your building is zoned. That information is very powerful and on both sides. It's important for you to know, and it can be weaponized against you by DOB attorneys. So educate yourself. Take that time. It's worth it.